Alright, Friday morning. This is the one they didn't see coming. Donald Trump's legal team walked into a high-stakes appellate showdown looking to freeze everything. They walked out with a flat refusal, an activated daily tracking system, and a conditional arrest order that is officially ticking down. The headlines are screaming about a constitutional crisis. I spent the last 6 hours pulling the fresh dockets, reading the Second Circuit's emergency brief, and analyzing Judge Patricia Morrison's supplemental filings from this afternoon. Here's what's actually happening behind the closed doors of the federal judiciary, while the public is looking at the hyperbole. The defense tried to build a legal wall. Judge Morrison just dismantled it brick by brick. Let's look at the raw data, the page numbers, and the specific mechanics that are driving this case toward a July 13th climax. Before we dive into the fresh documents from today, let's establish exactly where we are on the timeline. We are currently in a high-stakes enforcement phase of a massive civil fraud and compliance action. The core issue: a multi-state corporate web involving property transfers, refinancing agreements, and tax records across 7 states, specifically targeting major commercial footprints in Chicago, Miami, Phoenix, and Austin. 4 months. This was standard litigation. Extensions requested, extensions granted, deadlines pushed. But when federal oversight transferred the active enforcement of these subpoenas to Judge Morrison's district court in Manhattan, the rules changed overnight. Morrison, an experienced former federal prosecutor with nearly 2 decades on the bench, is known for running an exceptionally tight docket. She doesn't do litigation theater. Over the weekend, she dropped a $4.7 million contempt penalty and signed a conditional arrest warrant. If Donald Trump does not fully comply with the outstanding production orders by Monday, July 13th at 5 p.m. Eastern, the U.S. Marshals have explicit, pre-authorized instructions to take him into custody until compliance is met. The defense immediately scrambled. Late Sunday night, they launched an emergency appellate petition to the Second Circuit Court of Appeals, demanding an immediate stay, a legal pause button, on everything Morrison ordered. That brings us to the events of the last 48 hours. The appeals court met, the status reports hit the docket, and we now have the exact blueprint of how this showdown is playing out. The defense's entire strategy rested on getting the appeals court to stop Judge Morrison from enforcing the Monday deadline. I pulled the 3-judge panel's initial ruling filed today. Let's look at what the judges actually wrote versus what is being reported. On page 7 of the appellate record, Trump's defense team argued that forcing a former president and current 2026 candidate to choose between producing sensitive, proprietary financial data or facing physical detention constitutes immediate, structural, and irreparable harm that cannot be undone on subsequent appeal. The 3-judge panel didn't buy it. Writing for the court, the panel noted, the assertion of administrative burden or political disruption does not supersede a clear finding of willful non-compliance by the district court. Appellate intervention requires a showing of legal error, not merely a high-stakes consequence. What does that mean in plain English? It means the appeals court is refusing to act as a shield for the defense just because the penalty is severe. They are looking at the underlying conduct. This is where the defense's strategy completely collapsed today. On page 14, the panel addresses the $4.7 million in cumulative contempt fines. The defense argued that these fines should be frozen while the broader appeal over the scope of the subpoenas is argued later this fall. The court's response was definitive. It states, the appellant's financial entities have demonstrated an ongoing capacity to utilize the exact records in question for commercial gain during periods of asserted unavailability. Consequently, the coercive economic sanctions imposed by the district court remain fully operative. Let's translate that from legalese. The court is saying, we see that you're using these documents to get bank loans and close real estate deals in the private sector. You can't tell us they are too hard to find or under a locked audit when it's time to show them to a federal judge. The $4.7 million penalty isn't just active, it's actively accruing every 24 hours. Let's get into the actual evidence that made Judge Morrison lose patience in the first place, because this explains why the appeals court is refusing to bail out the defense. I went back through the cross-reference database compiled by the prosecution. They've been running a parallel tracking system for 8 months, matching public corporate filings against what Trump's lawyers were telling the court. The pattern isn't just an administrative delay. It looks like a highly coordinated, intentional data filter. Look at these 3 specific instances verified in the court record. First, look at the Austin Holding Company. On March 12, the defense denied having the records, claiming they were overly broad and non-existent. But just weeks later, on April 9, those exact tax and asset portfolios were submitted to a private equity firm in Dallas for a refinancing bid. Next, look at the Miami resort accounts. On April 22, they claimed strict attorney-client privilege over internal logs. But by May 14, 14 of those exact logs showed up in a standard commercial insurance claim in Florida. And the third one? Chicago real estate transfers. On May 30, they asked for a 60-day extension, claiming logistical impossibility due to server migration. Just 3 days later, on June 2, identical ledgers were delivered to a banking consortium in Zurich to verify liquidity assets. Look at those dates. Read that sequence again. When you tell a federal judge on a Tuesday that a document cannot physically be produced because your servers are undergoing maintenance, and then your corporate entity hands that exact same document to a commercial bank on a Friday to secure a multi-million-dollar credit line, you aren't fighting a legal battle. You're committing what the court calls selective compliance. That's why Judge Morrison used the term willful defiance 6 separate times in her original order. She didn't arrive at that conclusion because she was rushing. She arrived there because the prosecution gave her a mathematical receipt of every time a document was hidden from the law but exposed for profit. Now let's talk about what happened after Trump posted on social media calling the proceedings a witch hunt and claiming all documents were already available. Most commentators thought that was just standard political rhetoric. But inside a federal courthouse, words have immediate, binding consequences. Judge Morrison didn't issue a press release. She didn't go on TV. Instead, she quietly entered a supplemental order that completely shifted the tactical ground. She noted that if the defendant is publicly asserting that all documents are available, then there is zero logical or logistical reason for any further delay in their physical production. To enforce this, she instituted a mandatory daily reporting requirement. Starting Tuesday morning, Trump's legal team has been required to file an itemized status report every single day by 12 p.m. Eastern. This isn't a vague update saying, "We are working on it." The order explicitly states that they must provide the exact Bates-stamped number range of every document produced in the preceding 24 hours, the specific identity of the corporate custodian clearing the records, and a verified statement under penalty of perjury explaining why any remaining items on page 54's master list have not yet been delivered. I reviewed Tuesday's and Wednesday's filings. You can see the immediate friction between the lawyers and the client. On page 3 of Tuesday's status report, the defense noted they had successfully transferred 1,400 pages of banking records from a domestic institution. But when you look at the master demand list, those 1,400 pages only represent a single entity out of 14. By Wednesday's report, the tone from the defense became visibly strained. They filed a 12-page addendum explaining that international data laws were slowing down the extraction of records from certain offshore accounts. Morrison's response on the electronic docket was a single-line entry. The court notes that the international entities in question share a unified digital interface with domestic branches. Compliance remains incomplete. The clock continues to run. Let's step back and look at this objectively, because to understand where this firestorm is heading, we have to look at the legitimate arguments the defense is making. I talked to 2 corporate defense attorneys this morning, and they pointed out several elements of Morrison's order that are causing genuine anxiety within the broader legal community, even among lawyers who have no personal or political skin in this game. First, the sheer volume of the demand is historically unprecedented for a 7-day compliance window. We are talking about complete financial records, internal communications, tax returns, and banking data across 14 distinct business entities spanning nearly 3 years. In a normal commercial dispute, a request of this magnitude would take between 60 to 90 days just to run through a standard privilege review. When a judge orders a defendant to hand over all communications between the client, his attorneys, and his accounting firms, that directly touches the raw edge of attorney-client privilege. If a defense attorney is forced to dump thousands of emails into a prosecution database under the threat of their client being jailed in 72 hours, they don't have time to properly flag and redact protected legal strategy. Once that data is handed over, the privilege is broken. You can't put that bell back in the bottle. Constitutional law expert James Brennan argued in a supplemental brief yesterday that this compressed timeline creates an unconstitutional choice. He stated that the district court is effectively forcing a citizen to waive their fundamental right to privileged legal counsel in order to avoid immediate, pre-trial incarceration over a civil discovery dispute. This turns the entire architecture of due process on its head. There is also a valid question about whether an arrest warrant is a proportional tool for a civil enforcement action at this stage. Historically, body attachments, which is the legal term for a judge ordering federal marshals to physically detain someone for civil contempt, are used as an absolute last resort. They are usually reserved for individuals who are actively fleeing the jurisdiction, destroying evidence, or completely refusing to acknowledge the court's existence. Here, Trump's team is showing up. They are filing motions, they are entering appearances, and as of this week, they are filing daily status reports. Legal analyst Rebecca Torres notes that by keeping the arrest threat active despite the defense's partial compliance this week, Judge Morrison is taking the federal judiciary into uncharted territory. If the Second Circuit doesn't step in to modify the timing by Friday night, we are looking at a precedent where any federal judge can use the threat of immediate detention to bypass standard corporate discovery timelines. But here is the absolute core of the case that completely undermines the defense's argument about a lack of time. This is the piece of information that changes the entire trajectory of the narrative, and it's why Judge Morrison is moving with such absolute certainty. On page 47, paragraph 12 of the unsealed filing, the court documents detail a verified phone log from June 18. This wasn't a standard corporate call. It was an internal strategy session between Trump, key elements of his legal defense, and his primary accounting representatives. Through a completely separate discovery process in an overlapping state-level proceeding, prosecutors managed to obtain a partial verified transcript of that conversation. Look at the specific quote highlighted in the judge's written order. "We give them what doesn't matter. We hold what does." The court notes that it cannot definitively confirm the specific voice print of who uttered that exact sentence because it was captured on a multi-party speaker line. But the legal reality is that it doesn't matter who said it. The sentence was spoken within a formal consultation regarding an active federal document subpoena. The moment that line hit Judge Morrison's desk, the entire defense argument about logistical difficulties and complex corporate structures evaporated. In the eyes of the law, this isn't an issue of a defendant struggling to find old documents in a dusty warehouse. This is a documented strategy of deliberate concealment. It transforms an administrative delay into an intentional obstruction of the judicial process. That is why Morrison is treating this with such extreme urgency. She isn't reacting to public pressure or political cycles. She is reacting to a direct admission of strategic withholding that was captured in black and white on the record. We are officially 7 days from the original order, and exactly 4 days away from the final compliance deadline. Let's map out the realistic legal scenarios that could play out on Monday, July 13 at 5 p.m. Eastern. The first scenario is the full production dump. The defense team completes the extraction of all 14 entities' files, including the foreign banking records and the disputed tax returns, and delivers them to the Manhattan federal court clerk. If this happens, Judge Morrison will immediately cancel the status conference for Tuesday, lift the conditional arrest warrant, but likely retain the $4.7 million penalty for the expenses incurred during the delay. The case proceeds to a standard trial footprint, but the prosecution now possesses the full master database they've been fighting for. The second scenario is the 90% compliance compromise. This is the most volatile and likely outcome. The defense produces the vast majority of the files but holds back specific communications, citing unresolved privilege claims over a few hundred key documents. They file an emergency motion at 4:30 p.m. on Monday, claiming substantial compliance and begging for an extension on the remainder. If this happens, the ball is entirely in Morrison's court. She has the authority to declare partial compliance insufficient and execute the warrant anyway, Or she can temporarily pause the arrest order while forcing the defense into an immediate in-camera review, meaning she will personally read the disputed documents in her private chambers on Tuesday morning to decide if they are actually privileged. The third scenario is the flat refusal and execution. The defense stands its ground on constitutional principles, refuses to hand over the core materials before a full appellate review on the merits, and the deadline passes. At 5:01 p.m., the conditional arrest warrant automatically transitions into an active body attachment. The U.S. Marshals Service, operating under the explicit mandates signed on page 54 of the order, becomes legally obligated to locate and detain the defendant until compliance is verified. Because this is a civil contempt mechanism, there is no set sentence. There is no jury, and there is no bail. The law states that a civil contempt detainee carries the keys to their own cell, meaning the moment they order their team to hand over the documents, they are released. But until that happens, the detention remains structurally operational. Let's take a look at why this matter stretches far beyond the political fortunes of a single individual or the immediate news cycle. If you think this case is only about Donald Trump, you are completely missing the institutional shift occurring inside the American legal system right now. For decades, the standard playbook for high-net-worth individuals and massive multinational corporations involved in civil litigation was simple: outlast the system. If you have enough capital to retain elite legal counsel, you can file an endless sequence of procedural motions, dispute the definition of every single subpoenaed word, claim administrative burdens, and stretch a simple document discovery phase out over 3, 4, or 5 years. Most ordinary plaintiffs, whether they are a small business owner suing for a broken contract, an employee fighting for unpaid wages, or a local municipality dealing with a corporate environmental issue, simply do not have the financial runway to pay lawyers to fight through years of procedural warfare. They get exhausted, they run out of money, and they settle for pennies on the dollar. What Judge Morrison is doing right now is creating a highly scalable, digitally accelerated enforcement template that cuts through this dynamic completely. By using advanced software to cross-reference public, semi-public, and international business filings with outstanding court demands, the prosecution essentially automated the discovery verification process. Former federal prosecutor Amanda Chen pointed out this morning that this methodology is already being analyzed by corporate litigation groups across the country. If a judge can look at an automated database match, identify instant inconsistencies, and deploy conditional arrest warrants within an 11-day window based on a pattern of selective availability, the historic delay and complicated advantage enjoyed by wealthy litigants shrinks to zero. Imagine this applied to a standard commercial dispute. A large corporation claims it doesn't have the internal financial records to prove it violated a licensing agreement. Under the Morrison precedent, the plaintiff's counsel doesn't have to wait months for a series of hearings. They pull the county clerk records, show the corporation used those exact files for an internal merger last month, and demand immediate contempt sanctions within 48 hours. It completely rebalances the leverage dynamics inside a civil courtroom. I spent the afternoon cross-referencing statements from legal professionals across the political and ideological spectrum to find the genuine baseline of professional agreement. When you strip away the partisan spin, the structural consensus among experienced trial attorneys and constitutional scholars is remarkably uniform. Marcus Webb, a prominent defense-oriented legal analyst who has spent decades defending corporate executives in high-profile federal white-collar cases, admitted in a brief to clients today that Judge Morrison's order is exceptionally well insulated against standard appellate reversal. He noted that Morrison didn't write a standard, reactionary contempt order. She wrote an appeal-resistant fortress. By explicitly dedicating over 10 pages to anticipating and systematically refuting every single procedural objection the defense could make, she effectively tied the hands of the appellate panel. They can't claim she didn't consider the logistics. She listed the logistics and proved they were textually contradicted by the defendant's own corporate filings. Multiple prosecutors from the Southern District of New York have pointed out that while the media is obsessed with the physical arrest warrant, the real structural damage to Trump's broader legal position is the negative inference instruction. Let's be very precise about what this means. If this case goes before a civil jury later this year, the judge will explicitly instruct that jury that the defendant deliberately chose to withhold specific financial documents from the court. The jury will be told that, as a matter of law, they are allowed to assume that whatever was inside those missing documents would have conclusively proven the prosecution's case of financial fraud. Think about how devastating that is in a trial setting. The prosecution doesn't even need to show the jury the documents anymore. They just show the judge's instruction. The defense can present the most eloquent closing argument in the world, but they cannot cross-examine a legal instruction given by a sitting federal judge. That is why criminal defense expert Sarah Pacheco described the June 18 phone log transcript as an institutional tactical nuke. It didn't just trigger the Monday deadline. It structurally compromised the viability of the entire defense framework moving forward. We cannot look at this case in a vacuum. We have to acknowledge the elephant in the room: the structural timing of these legal maneuvers relative to the political calendar of 2026. The compliance deadline is Monday, July 13th, at 5 p.m. Eastern. The initial state and regional primary debates for the upcoming election cycle are scheduled to kick off in less than a month. The defense team is leaning heavily into this reality, arguing that the velocity of Morrison's enforcement action is explicitly calculated to create maximum political disruption during a critical window of the campaign. They point out that the civil fraud case itself has been active for over 2 years, so there is no objective judicial reason to suddenly compress the final enforcement phase into a matter of days right as the political calendar intensifies. Conversely, the prosecution's argument is that they have been methodically pursuing these exact records for over 8 months. From their perspective, the defense is attempting to use the election cycle as a permanent get-out-of-jail-free card to avoid standard compliance rules that apply to every other citizen. The legal reality is that both arguments can be true at the same time. The prosecution can be running a legitimate long-term compliance investigation that finally reached its boiling point, while the defense can look at the resulting timeline and see a clear political impact. But inside a federal courtroom, the political calendar holds zero evidentiary weight. Judge Morrison's job is to protect the integrity of her jurisdiction's subpoenas. Her written order made it clear that the court's calendar will not be dictated by outside events. As we head into the weekend, the operational tempo of this case is going to accelerate dramatically. Here are the specific, unvarnished milestones we are tracking over the next 72 hours. On Friday, July 10th, the prosecution will file their formal response to the defense's partial compliance filings from this week. They will lay out exactly which files are still missing from the 7-state property list and argue whether the defense is acting in good faith or continuing to stall. By Saturday, July 11th, we anticipate the 3-judge appellate panel will issue their final, written decision on whether to grant a formal stay of the arrest warrant. If they deny the stay, the Monday 5 p.m. deadline becomes completely absolute. On Monday, July 13th, at 12 p.m., the defense will file their final mandatory daily update on the Manhattan docket. This document will show exactly how many pages were turned over during the weekend scramble and will give us the first clear indicator of whether they are going to achieve full compliance or trigger the warrant. Then at Monday, July 13th, 5 p.m., the definitive deadline hits. The clock hits zero. Either the compliance certificates are signed by the court clerk, or the body attachment order goes live for enforcement. Finally, on Tuesday, July 14th, regardless of what happens on Monday evening, Judge Morrison has scheduled an in-person status conference in her Manhattan courtroom. If compliance was met, this will determine the final disposition of the $4.7 million in fines. If compliance was refused, this conference will handle the logistics of the ongoing detention structure. The legal mechanics are set, the documentation is cross-referenced, and the judicial framework has been locked into place. The days of procedural negotiation are officially over. We are now in a phase of absolute enforcement. I will be tracking the docket updates live as they hit the system over the next 48 hours. Drop your analytical predictions in the comments below. Let me know how you see the partial compliance defense holding up against the June 18th intent logs. I'm not done with this filing yet. There are layers regarding the Swiss banking tracking data that most outlets haven't even deciphered. Stay tuned. Hit notification on. When the next docket drops, we will break it down line by line, right here.